Hi, my name is Ben England. I'm the founder and CEO of FDAimports.com and Benjamin L. England & Associates. We represent hundreds of companies around the world before the FDA, the U.S. Department of Agriculture, and Customs, helping them with importing safe food into the United States. Today I wanted to talk to you about the Food Safety Modernization Act and FDA's new proposed regulations on standards for produce safety. Now, FDA has been in the produce safety business for a while, but primarily through guidance documents that are called good agricultural practices. FDA never tried to exercise actual regulatory authority over produce safety. The U.S. Department of Agriculture had some jurisdiction there. FDA was in the field, so to speak, but they weren't really creating any regulatory power. And under FSMA, they were given the authority to establish standards that were regulatory standards for produce safety. Now, when FDA issued its regulations, you can see a couple of high points that we wanted to bring to you. The first had to do with some inventive language that the FDA undertook. The statute, when it was originally passed, failed to include an adulteration charge. And what that means is that even if someone failed to comply with the standards for produce safety, that didn't cause the food, the produce, to become adulterated under the law, which limited what FDA could do with respect to that food product. Now, FDA could criminally prosecute the person responsible for the failure, but they couldn't do anything about the food. Now, if it was unsafe, that's different. They already had that authority anyway. Well, the FDA, when they were given the authority to create these standards, they decided to write in their own authority to call the food adulterated if someone fails to comply with the standards for produce safety. And they used a provision of the law that's called the insanitary charge or adulteration charge. And basically what the statute says, the original statute for food and drug law, says that if you were to prepare, pack, or hold food in insanitary conditions, then that food would be adulterated. Now, that language is not in the standards for produce safety. What FDA did was they stuck in their new provision, their new regulation, they stuck in language that said, if you fail to comply with standards for produce safety, then we will deem your food adulterated because it has been prepared, packed, or held in insanitary conditions. Now, that seems reasonable. The problem FDA has is the language in the adulteration charge itself. What FDA did was they said that the growing of food, well, that's what happens on a farm. You plant seeds, you put water on it, the sun shines, the food grows. You harvest the food. That's what happens on a farm. It might be packed, pre-washed into a truck and sent to a packing operation or a packing house or some processing facility. The farm very often isn't performing those steps. They're just growing and harvesting. So how is that preparing, packing, or holding food? Well, FDA says that growing and harvesting is preparing food. Now, I don't know that I agree with that, and I'm not sure that Webster or Oxford agree either. For instance, in the Merriam-Webster online dictionary, the word prepared means, quote, to make ready beforehand for some purpose, use, or activity. Now, it's true that growing and harvesting happens beforehand, but is that the kind of activity that people think in terms of preparing food? Merriam-Webster doesn't really agree. They use this as an example, quote, prepare food for dinner. Now that sounds like preparing food to me. If you go to the Oxford Dictionary, you find something very, very similar. In the Oxford Dictionary, the word prepare is used in the context of making food or a meal ready for cooking or eating. Now it's true, prior to cooking and eating food, you have to grow and you have to harvest it, but is that really what people think when they use the word prepare? I don't think so. I think FDA is creating authority here. Congress didn't give it to them. They're making it up because they needed to come up with something to do with the food if you fail to comply with the standards. It's something that you should consider commenting on because I think FDA is far afield, so to speak, of its authority here. The second thing I wanted to talk to you about has to do with some exemptions in the standards. Now, we see in the FDA's regulatory rubric and their scheme that they're primarily focusing on foods that are consumed raw. The kinds of foods that you might be able just to take off of a vine and wash and then eat. And so they exempted some foods that they don't think fall into that category. That includes things like asparagus, cranberries, potatoes, sweet corn, and winter squash as examples. These are foods that people don't usually eat raw. Usually you have to prepare them in some way by cooking them or putting them through some kind of a process. Now, they also, however, included some interesting foods as well that you might not expect. Foods for which there's never been any real recall or outbreak associated with them, and it's relatively limited in how the food might become contaminated. And examples of that would include lemons and oranges and limes. And I bring this up because if you think, for instance, when you go to a restaurant and they bring out to you a drink and you have a little lime and you put a little lime twist into your drink, if you think about that lime twist, what's the part of that food that you're really consuming? It's that fleshy, juicy, sweet, sour part, right? It's not the rind. It's not the outer part of it. And that's the part that's available for contamination in transportation and packing and holding. But FDA included them anyway into these standards. And I think it's something the industry should look at and consider whether the FDA has overreached there as well. The last big point I wanted to bring up had to do with a warning letter that was issued on the same day as these regulations, and that warning letter went to a farm that in 2012 was associated with a salmonella outbreak due to some cantaloupes that they had distributed. Now, the important thing here, you should go to our blog and you'll see what we've done with this. We've taken this warning letter and you see how FDA has outlined the things they thought were wrong on the farm. You can go to the FDA's proposed regulations and find a charge for every single one of those items. And so here you see the FDA actually implementing its thinking process with respect to these standards. And it allows you to watch them sort of work them out in a warning letter process. Those were the things we wanted to talk to you today about, the standards for produce safety under the Food Safety Modernization Act. I'm Ben England at FDAimports.com, and thanks for watching.